Such circumstances do not satisfy Hawk v. Smith that speaks of, quote, deliberative assemblages representative of the people, quote unquote, in discussing Article 5 conventions. In order to be deliberative, elected delegates must debate and resolve amendment proposals as is done in Congress. Not that people would not like to also limit Congress, save for the speech and debate clause. In Gravel v. United States, the court said the heart of the clause is speech or debate in either house, and insofar as the clause is construed to reach other matters, they must be an integral part of the deliberative processes by which members participate, with respect to the consideration and passage or rejection of other matters which the Constitution places within the jurisdiction of either house. The court mandates that conventions are deliberative. It uses the same word describing other matters which the Constitution places within the jurisdiction of either house, such as debating proposed amendments. It's not much of a leap to state any effort to limit a convention violates the speech and debate clause. To do so denies delegates the equal opportunity to debate proposed amendments as is afforded members of Congress. The only way to limit a convention should be by election. The people elect delegates with particular amendment positions. At convention, after debate, these delegates prevail. For those unfamiliar with this process, it's known as a Republican form of government. People assume the purpose of state applications is applying for a particular amendment proposal. Black's Law Dictionary defines an application as a request or a petition. Simple rearrangement and substitution of synonym permitted by English grammar clarifies the meaning and intent even to those who will not read it. On the request of 2/3 of the several state legislatures, Congress shall call a convention. The purpose of an application is to cause a convention call, not to propose an amendment. All state applications request a convention call and therefore are in full force and effect. For years, JBS has gone about convincing state legislatures to rescind their applications with no legal proof such rescissions are even constitutional. The results are dubious. Since JBS began its campaign in the 1980s, the states have submitted nearly half of the 750 applications now on public record. Rescissions are invalid because in both Hawk v. Smith and U.S. v. Sprague, the court stated Article 5 is plain in meaning and requires no rules of construction. Thus, there are no implied powers. As noted in Hawk, when acting in the amendment process, states operate under the authority and limitations of Article 5, not their own state constitution. Article 5 grants no authority for either Congress or the states to rescind applications. Therefore, such rescissions are unconstitutional. If such implied powers existed, Congress, rather than the states, would rescind the application. Only Congress has the authority to remove items from the congressional record, which is where the applications are placed. As the power is implied, Congress could easily interpret it as authority to rescind applications, even if the states did not request it. 3, Congress has never officially rescinded any application. Madison v. Marbury states a legislature cannot act repugnant to the Constitution. Public record shows the state submitted sufficient applications for a convention call prior to any rescission being submitted. Therefore, the convention call, being peremptory, preempts any state rescission as the terms for a convention were already satisfied. Now, turning to my lawsuits, some have suggested that my suits lack standing and therefore they are meaningless. Now, without question, standing is a legislative power, not judicial, as demonstrated in McConnell v. FEC, where Congress defined standing legislatively. Nonetheless, there is no law defining the terms and condition of standing, as standing has a dubious history of consistency. Even Chief Justice Rehnquist in Elk Grove Unified School District versus Newdow spoke of the, quote, novel prudential standing principle raised by the court to avoid reaching the merits of the constitutional claim. There is one consistency, however. If a party lacks standing, the court lacks jurisdiction to make a ruling. Standing is based on the Cases and Controversy Clause of Article 3. On these two rocks of legal document, the doctrine of standing rests. There are some problems, however. First, the Constitution describes 3 legal petitions that can be brought before a court, not 2. Cases, controversies, and suits. Suits are described in both the 7th and the 11th Amendment. Now, I'm sure that all here are well observed or well knowledge of the well-settled principle of law as expressed in Wright v. United States, for example, that the Constitution, in every word, must have its full due force and appropriate meaning. Thus, suits are a distinct form of legal petition permitted by the Constitution. Further, the 11th Amendment directly amended Article 3. Hence, the correct constitutional term is cases, controversies, and suit. Despite this, the Supreme Court has never addressed suits in any ruling on standing. The only possible conclusion, given these circumstances, is standing is not required to file a suit. I filed suits and so designated them. Therefore, I required no standing. Moreover, my suits dealt exclusively with the amendatory process. In Coleman v. Miller, the court ruled any court opinion in the advisory process is advisory, which of course requires no standing. Then there is the fact members of Congress, by refusing to call a convention, violate federal criminal law. There is no standing required in criminal law. Public record proves that 39 states have applied for repeal of federal income tax, one state more than is needed for ratification. Congress' refusal to call violates the Constitution and prevents repeal, thus allowing continued collection of the tax. Income tax law permits reparation of such tax if it is collected in violation of the Constitution. I sought reparation under federal income tax law, which grants standing for those seeking reparation. The Supreme Court has ruled in 4 decisions that Congress must call a convention if the states apply. Dodds v. Woolsey, 1855, Hawk v. Smith, 1920, Dillon v. Gloss, 1921, and U.S. Sprague, 1931. The words in these 4 decisions make it impossible to reach any conclusion but that Congress has no option to call a convention if the states apply. In Walker v. United States, the district court nullified the words of these 4 court decisions by simply ellipsing them out of a reference it quoted that used them. Second, the court applied the political question doctrine in Coleman to justify the nullification. Political question doctrine has never been applied to a convention call, as it is peremptory. The only possible interpretation of the 2 rulings is the court believed under the political question doctrine, Congress had the option not to call a convention despite the direct language of the Constitution. Before my suit, a convention call was peremptory, with Congress having no option. Afterwards, a convention call was optional, with Congress having the authority under the political question doctrine to veto the direct language of the Constitution. Clearly, the court ruled, meaning, if nothing else, I had implied standing. Coleman v. Miller is usually characterized as a plurality decision and thus assumed to be of dubious authority. What is missed is the decision is based on all reasons given by the justices, and therefore all parts apply, making its authority the same as any other decision. Only one part of Coleman discusses the constitutional amendment process as opposed to ratification, which was the main subject in Coleman. As the district court used Coleman, this portion must be the basis of its ruling. In that portion, the Supreme Court assigns Congress, quote, exclusive, sole, complete, undivided control of the amendatory process. The court stated, quote, Congress, possessing exclusive power over the amendatory process, cannot be bound by and is under no duty to accept the pronouncements upon the exclusive power by this court. Therefore, any judicial expression amounting to more than mere acknowledgement of exclusive congressional power over the political process of amendment is a mere admonition to the Congress in the nature of an advisory opinion given wholly without constitutional authority, unquote. Now, if I'm incorrect in these assumptions, the 4 previous decisions that I just cited prevail. Either Congress must obey the peremptory language of of Article 5, or it does not have to. There is no middle ground in this. My second lawsuit, Walker v. Members of Congress, established the official, formal position of the members of Congress on a convention call and presented the issues to the Supreme Court, including the criminal violations by Congress. To that end, I filed individually against all members of Congress. Members were allowed to opt out by declaring support of Article 5. No member did this. Thus, for the first time in United States history, Congress chose to express public opposition to obeying the Constitution. Trial was held at Ninth Circuit Court of Appeals, as the United States chose not to appear at district court. The district court had previously reaffirmed the ruling in Walker v. United States. At trial, the U.S. attorney refused to answer who they represented and under what federal law the Department of Justice had authority to appear. After several motions, the court ordered the United States to answer these questions. The attorney stated in writing she had letters from both House and Senate counsels instructing her to oppose my lawsuits. Under federal law, House and Senate counsels cannot act without votes of Congress instructing them to do so. Further, federal law mandates before the DOJ can represent any member of Congress, each must individually request such representation. Therefore, I can state every member of Congress determined of his own volition to oppose obeying the Constitution and instructed their attorneys of record to proceed on that basis. When that decision became public record, the members of Congress violated their oath of office. Executive Order 10450 defines the terms of violation of oath of office as described in 5 U.S.C. 7311, and provides, quote, the alteration of the form of government by the United States by unconstitutional means, unquote, is a violation of oath of office. Our form of government prescribes 2 methods of amendment proposal, not 1. It does not give Congress the authority to refuse calling a convention. I appealed to the Supreme Court, which ultimately denied me certiorari, meaning the court upheld without review the lower court's decision that based on the advisory opinion of Coleman, Congress could veto the Constitution under the political question doctrine. However, before the court ruled on the certiorari appeal, the Supreme Court Rule 15.2 demanded for the first time in the proceedings the United States address the issues of fact and law raised in the suit. The rule reads, quote, a brief in opposition, in addition to presenting other arguments for denying petition, should address any perceived misstatements of fact or law in the petition that bears on what issues properly would be before the court were certiorari granted. Consuls are admonished that they have an obligation to the court to point out in the brief in opposition, and not later, any perceived misstatement of fact, any perceived misstatement made in the petition. This rule forced the government to actually address the issues presented rather than hiding behind standing. The United States either had to state I was correct as to fact and law, or I was not. I stated the following in my brief before the Supreme Court. The convention call is peremptory. There are sufficient applications on record already to cause a convention call. 3, a convention call is based on a simple numeric count of applying states with no other terms or conditions, such as rescissions, same subject, contemporaneous, and so forth. 4, by refusing to obey the Constitution and so advocating the same in a public forum, the members of Congress violated their oaths of office and other federal criminal laws. The Solicitor General of the United States, acting both in his official capacity and as official attorney of record for all members of Congress, after consultation required by federal law with those members, formally and officially waived response to my brief. Thus, he formally and officially acknowledged what I had stated in my brief was and is correct as to fact and law. This is what I mean when I state that the only group I've ever been able to persuade is the United States government, as this is the only official government act on the convention call in United States history to date. As to the criminal offenses I have mentioned, 5 U.S. 7311, violation of oath of law, 1 year in federal prison, forbids any person from, quote, holding or accepting federal office. As public record shows, Congress has refused to call a convention over an extended period of years involving numerous members. 18 U.S.C. 371, conspiracy to defraud the United States, 5 years in prison, applies. According to the Congressional Research Service, conspiracy need not be about money or property. Quote, the scheme may be designed to deprive the United States of money or property, but it need not be so. A plot calculated to frustrate the functions of a governmental entity will suffice. The governmental entity, in this case, of course, is the convention, which is clearly assigned specific authority and power by law, and one whose function is frustrated by the conspiracy of members of Congress. Then is obstruction of government proceedings under 18 U.S.C. 1505, another 5 years in prison. The convention call is a proceeding pending before Congress. The law states, quote, whoever corruptly or obstructs or endeavors to obstruct or impede the due and proper administration of the law under which any pending proceeding is being had before any department or agency of the United States shall be fined under this title or imprisoned not more than 5 years, unquote. By obstructing the convention call, members violate federal criminal law. For years, Congress and the judiciary have played a tennis match with the convention call. Congress says the judiciary must rule before it acts, yet it opposes any suit allowing for the court to do so. The judiciary says a call is a political question for Congress to decide. The tennis match continues. Both Congress and the judiciary void the Constitution, and the people are screwed. The tennis match needs stopping by changing the game. The game is now about civil and constitutional law, which both sides sidestep. Criminal law is clearly the purview of the judiciary. Given the criminal offenses, the issue is no longer about a convention call, but whether the judiciary will permit Congress to commit criminal acts. If not, a call will result. If so, the Constitution is reduced to no more than an advisory text. And how is the game changed? You simply say, quote, Your Honor, I wish to present to your evidence that members of Congress have violated federal criminal laws and formally request you undertake, as required by your oath of office, such actions as necessary to bring those people responsible to justice, unquote. After that, it's up to the judiciary to decide whether the Constitution continues to exist. Then you simply sit down. Thank you.